Hello and welcome to Legal Talk, a program brought to you by the law firm of O'Donnell, Weiss & Mattei, PC. We have full-time offices in Pottstown and Phoenixville. And also we ask you to join us at our website, owmlaw.com. Today's program is one that impacts every one of us. Eventually we all die. And today's program is about death and its legal implications. I'm David Kaplan, and joining me in this program, I have James Kovaleski, who has his master's in tax law, and Rebecca Hobbs. Becky is one of two attorneys in our office who are CELATs, Certified Elder Law Attorneys, which is quite a distinction. Actually, both of our members of the firm are very distinguished people. So, death impacts all of us. We all die. But does that mean automatically when a person dies that we have to go into court and establish an estate? Jim, is it automatic, or when does a person have to actually establish an estate?
I'm going to give you the tried and true lawyer response. It depends.
Okay.
It depends on the facts and circumstances. Sometimes it is necessary. It's necessary generally when there's a piece of property or piece of an asset or something that the decedent, the person who died, owned in their own name. There's also times when it's not necessary. A lot of times with a husband and wife, it may not be necessary. But if a person dies owning a piece of property in their own name, usually the only way to transfer it is to go through the process of opening up an estate, having an executor and executrix appointed, and then that person can handle or administer that piece of property or properties.
So typically, husband and wife situation, one dies, they've owned their home in both names, they own their bank accounts in joint names. Everything's in joint names except maybe a retirement account, but the spouse is named as the beneficiary of that. Is it necessary to establish an estate in that situation?
No, you're actually talking about my wife and I. That's exactly how we have everything set up. All the accounts are jointly owned. Our real estate is jointly owned. We both have retirement accounts, but we're both the primary beneficiaries on those. Same thing with our life insurance policies. So if I get hit by the proverbial bus today going home, my wife is not going to need to go through probate. I will say that there is one thing that I do own individually, and that's my car. But I think we're going to get to that and talk a little bit more about that later. So
okay. So, but if you own stock in a corporation,
good point. If I own stock in a corporation that is only in my name, then yes, I might have to go. My wife might have to go through probate because under my will, she's named as the executrix, so she would be in charge of going through the process of probate, bringing my will, being appointed executrix, and to address that stock. If that stock is not addressed someplace else, like a shareholders agreement.
Okay. So now you've said the magic word probate.
Yes.
And Becky, for a lot of people, they somehow get worried about that. That's a dirty word, probate. Is it a dirty word? Is it hard in Pennsylvania?
It's not. So in Pennsylvania, the probate process is relatively simple. So the word probate just refers to the process whereby you take the will to the Register of Wills, and the will is established judicially as being the duly executed last will and testament of the decedent. And that's where somebody passes away with a will. And then the probate process where someone passes away without a will is referred to as the intestacy succession. So it's establishing the heirs of the decedent.
Okay. Where do you go to establish this estate?
Mm-hmm. So you look to the county where the decedent was last domiciled. So you look to that county, and then you would go to the local county Register of Wills in that county.
So typically in our viewing area, people would be going either to Norristown or Westchester or to Reading.
Correct.
And I know we go to those counties and others with people to establish estates. Is it a complex thing? I mean, there's a petition that has to be filled out.
Mm-hmm. Yeah, so the first step where you do need to probate an estate, the first step is the preparation of the probate petition. And that requires certain information that you need regarding the decedent. and you have to have an original death certificate. But the actual probate process is taking that petition, the death certificate, the original will, if the decedent had an original will, taking that to the Register of Wills, and then that day you leave with either the letters testamentary, which is where the person passed away with a will, or the letters administration, where the person passed away without a will. And then really the more complex part of the probate happens after that initial probate proceeding. And that's where the administration of the estate occurs. But in Pennsylvania, it is relatively simple. It really depends on what type of assets the individual owned when they passed away. That determines the complexity of the estate, as well as the heirs that are involved.
Okay, and it's not that expensive normally to establish an estate to probate.
Yeah, so the county has a list of fees that go along with when you file that petition for probate. And that fee is relatively inexpensive. It ranges depending on the size of the estate. So at the time that you probate, you estimate what you believe the size of this estate may be, and then they have a fee based on that. But then the fee comes down to how many pages are in the will, and different filings that go along. But usually you're looking about $200 to $400, depending on those various factors for the actual
and the size
probate.
of the estate. Sure.
Right.
And of course, who goes to that probate?
Mm-hmm. Yeah, so the person that goes to the probate would be the executor named in the will that is going to be serving. Or where there is no will, it would be the person that wants to serve as the administrator. And that depends on, for example, if a decedent passes away and they're married, then that would be most likely the spouse that would be entitled to serve as the administrator. Or where there are children, one of the children, so the person that wants to actually act as the administrator.
Okay, and sometimes there can be conflicts on that, but hopefully most families work that out.
Right, yes, there definitely can be conflicts, which is why it's so important to have a will, because that helps to, get rid of those conflicts at that time, because the will is where you're nominating the person that you want to act as your executor. So most of the conflicts come into play where you don't have a will and you have multiple people that could serve as the administrator. For example, I'm one of 6 kids, so if my parents didn't have a will and passed away, then we would have to decide among ourselves, out of the 6 of us, who would serve, where it's better to just have that will and nominate the person.
You're right. And of course, when you get down, I don't want to go on and on about probate, but it's not a long process. Usually you're in and out of there in, 15, 20 minutes at the most?
Yeah, it really, the actual probate process where you're submitting the petition with the will or establishing the heirs is not a long process. It really is, depending on, if there's other people in front of you and you're waiting, but usually it's about 15 to 20 minutes, and you leave the Register of Wills with the documents generally that you need.
Most counties. It used to be when I started practicing a long time ago that everyone had to give bond, or many people had to give bond for their faithful performance as an administrator or executor. And today that's actually fairly rare. And we actually include language in our wills that handle that.
Right. Yeah, so, and that speaks again to the importance of having a will. So if you have a will, you want to make sure you check the document to make sure there's a waiver of bond within the document. And that would allow your executor, if they're out of the state of Pennsylvania, to go and probate without needing to post a bond. Where you die without a will and you have an administrator that's out of state, it just adds another layer of complexity. So another thing that has to be done that can delay the process.
Okay, so now you've established an estate, and Jim, when we leave, Becky said we usually try. We hope that the Register of Wills will give us certain documents when we leave their office. That's what the short certificates that's often referenced, and what's the purpose of the short certificate? What's that allow us to do?
Really, that's probably the most important document that comes out of the probate process. What that document is it's an official document issued by the Register of Wills from whatever county you're going through probate that says the executor, the administrator, whoever that person is actually authorized to act on behalf of the estate. So if, that includes going into something as simple as the bank to close down the accounts for the decedent, for the person who passed away. If Jane Doe had accounts at a bank, the executor can go in and prove to the bank that Jane Doe has passed, that they are the person authorized to act with that short certificate, and actually close down the accounts, because that's part of their responsibility, is to start marshaling assets.
Jim, actually, that's you're responding to my next question already, and that's good. That's good. Next question really is, now we have the short certificate, and what's the job of that? We use these terms interchangeably. We talk about executor, administrator, personal representative. They're both personal representatives, depending on whether there's an estate or a will, not a will, whether the executors had to be replaced by someone. It's a different type of administrator. But the personal representative, what is their job then when they get the papers? What can you summarize it?
Sure. At the beginning of an estate, there's actually a lot of things for that personal representative to do. Send out notices to people that are named in the will or that are otherwise entitled to a notice of beneficial interest, a potential interest in the estate. So that's required. If you don't do that, the Register of Wills is going to start sending you reminders if you go beyond the timeline that's prescribed for that. The executor also goes out and opens up an estate account, because usually most estates will have some sort of liquid assets, usually from the decedent's bank accounts, checking account, savings account, something like that. So they'll open up an estate checking account where they'll deposit estate assets into that'll be later used for bills, for distributions if there's money left over going out to the beneficiaries. They'll obtain an EIN. They'll put...
what's an EIN?
Basically a social security number for the estate.
Okay.
It's the easiest way I can explain it.
Employer's identification number.
Yes.
Right?
Again, another thing that goes by many names. EIN, TIN, taxpayer identification number, they all mean the same thing. It's basically a number that you've now been issued from the IRS that identifies the estate with the IRS. There are also, I alluded to it earlier, their responsibility is to marshal assets. So whether that's making sure that if there's real estate, that real estate is protected, it's secured so that no one can get into it, whether it's going to the bank to close accounts, going to investment advisors to potentially liquidate investment accounts or at least move investment accounts into an estate account. All those type of things, that's the responsibility, and that should be done relatively soon after probate, so that the executor is doing their job of protecting those assets so that they're not dissipated or wasted in some way.
And Becky, I know that there's payment of bills, and we usually do advertising.
Right.
It's not I guess not in every estate, but we usually do.
Yeah.
What's the purpose of that?
Yeah, so the purpose of advertising, which actually anytime letters of administration or letters of testamentary are issued, so anytime you do probate an estate, you are required to advertise that the estate has been probated. And the purpose of that is to run the statute of limitations for when a creditor can come forward and request payment from the estate. So from the date of advertisement, there's a 1-year statute of limitation for a creditor to come forward and present notice to the executor that they're due a balance from the estate. And then after that 1 year has expired, then they can't come forward anymore against the estate. So it's really a protection for the executor.
So I'm a personal representative of an estate, and if in fact I fail to pay proper bills, can I be held responsible?
You can. So there is personal liability for an executor, but that statute of limitations with that advertisement is that built-in protection for the executor.
Okay.
So if the executor doesn't have notice of the bill, so if you're not aware that there's an outstanding hospital bill, then there is no liability there. It's only where you're aware of it and you don't pay it, and that awareness happens within that 1 year.
So, and again, if a year and a half after you've advertised, the hospital decides or somebody else decides to give you a bill, and you can snub your nose
Exactly.
to them.
Yeah. Now the one complexity with that is that there's, and we're going to get into this probably in a little bit, but there's two different ways really to settle an estate, which is formally to settle an estate through filing a first and final account.
And we should probably preserve that for the second part of the program. We're going to take a real quick break to hear from our good sponsors. We'll look forward to seeing you on the other side.
For over 50 years now, O'Donnell, Weiss, and Mattei have helped their clients resolve a wide variety of legal challenges. OWM Law provides legal representation to clients throughout southeastern Pennsylvania. The attorneys and highly trained support staff utilize the latest technology and resources available to satisfy the needs of their clients. O'Donnell, Weiss, and Mattei, delivering the highest level of professional service.
Welcome back to Legal Talk. I'm David Kaplan. With me, we have James Kovaleski and Rebecca Hobbs. We are talking about the uplifting and exciting topic of death and its legal implications, which actually can be very interesting and frankly impacts all of us. We just talked about when it's necessary to establish an estate, the basics of what you do when you establish an estate and the responsibility of a personal representative. And we were talking about, Jim talked about marshaling of assets, gathering the assets, and Becky started talking about paying bills. One of the big bills that comes up is taxes. And there are actually various types of taxes we have to look at in every estate. I'll go back to you, Rebecca, and just say, what kind of taxes are we looking at here?
Yeah, so one of the main taxes you're looking at is Pennsylvania inheritance tax, which there's a common misconception that when you avoid probate or you don't have a probate estate that you avoid Pennsylvania inheritance tax, and that's not true. So Pennsylvania taxes almost every asset but life insurance. So real estate, even non-probate assets like IRAs, brokerage accounts that have a beneficiary designation.
Retirement accounts.
Yeah.
Sure.
So Pennsylvania taxes all those assets. So even if you don't have a probate estate, you still have to be mindful of the rules that come along with the Pennsylvania inheritance tax. They also tax joint accounts where it's not a husband and wife. So if you have like a child on a joint account, they're still going to tax that account. That's something to be aware of. So Pennsylvania taxes the first dollar of an estate. So there isn't a certain amount that's exempt from inheritance tax. Now the rates do vary. So for example, for a spouse, there is no tax. It's a 0% tax rate. Children pay at 4.5%, and then it's graduated where siblings pay 12% and everyone else at 15%. Unless you're an exempt, like a charity or a governmental agency, then you're taxed at 0% as well. So that Pennsylvania inheritance tax is really important, and there are certain deadlines that can sneak up on you, which is why it's important to consult with an attorney when you are presented with a situation where a family member or a friend passes away and you're inheriting from the estate because of those deadlines. So for example, when someone passes away, if you pay the tax within the Pennsylvania inheritance tax within 3 months from the date of death, there's a discount on that tax. And that can be very helpful where you're presented with a large tax bill. But the other deadline to be mindful of is a 9-month deadline that you have to file an inheritance tax return and pay the tax within 9 months from the date of death, or you're looking at penalties and interest that start to accrue.
Now let me just, there are other taxes involved. Jim, you're the tax guy, you're the master's in tax law. We have, income tax and the federal state tax potential. Mm-hmm. Tell us, what kind of income tax are we talking about?
So there's two, they're both income taxes, but there's two tax returns that we're concerned about. If a decedent lived one day, even one day into a year, they pass away on a January 1st, say 2017, because we're coming upon that date soon, they would have to file a final federal tax return, personal income tax return, as well as a final state income tax return for that 2016 where they lived the entire year, but also for 2017, the year that they only lived a day in. So that's one of the tax returns on the income tax side that we're worried about.
And I guess that's important because for a lot of reasons. One thing is you always mark at the top of that final return, and it is a final return, the person's deceased, so that the IRS is not looking for them.
Exactly. I mean, not only are you required to file it because you potentially had income, but yes, you mark it final so that a year from now, 2 years from now, you don't get a letter from the IRS, hopefully not certified particularly, saying, where's this, where's that? As the executor or executrix, that's probably one of those gut check moments that you want to avoid. So you want to make sure you file those tax returns and mark them final.
Now you mentioned, okay, that's the final personal return, and then you mentioned that the estate also may have to file a return, and I'd say may, it's not in every case, and it's called a fiduciary return.
Exactly. Just like a business, the IRS looks at the estate as a separate entity, so that the estate potentially might have to file an income tax return, fiduciary income tax return, if the estate had income that was generated while the administration was going on. So let's say the day after the decedent passed away, there's a huge spike in their investment accounts due to appreciation. The estate sells those, and for some reason the money is kept in the estate. The estate might have a responsibility to pay tax on that gain, on the income that it experienced because of that increase in the value of those assets. So, yes, that's a possibility, but it's not all. Not in all states do we file the fiduciary income tax return.
Yeah, and you actually potentially have to do that for every year the estate is open.
Just like us as individuals, once we started working, depending on if it was before or after 18, whatever, we filed our annual personal income tax returns. Yep, for every year the estate's open, you might have to file a final one or file a fiduciary income tax return.
And I guess it's important that it's done properly because you're talking about profits, but sometimes there are losses, and those losses can be passed through in a good way to the beneficiaries, can't they? It's going to K1 is, I believe?
Exactly. I mean, getting back to the earlier point I made, it's just like a business. So if you have a business that is required to file its own tax return, say a C corporation, not to go too far afield, or something else, there might be the possibility, or a partnership, I'm sorry, not a C corp, where there's losses or income on the flip side of that coin that gets passed down to the beneficiaries that they have to report on their individual tax return. So it's important to do that correctly at both levels and potentially have an accountant assist you so that you make sure that you do it correctly on both levels.
And there's always that political football called federal estate taxes everyone worries about. And I don't know, what percentage of the population does that impact?
Oh gosh, I at this point I think it's less than 1%. I mean, it's right now the exemption amount is north of $5.4 million. So for an individual that's not married, that has died and has not made any taxable gifts during their lifetime, so that's a couple caveats on that, but they can pass $5.4 million under the federal estate tax guidelines without paying any federal estate tax on there. So fortunately, unfortunately, there's not a lot of individuals out there that have $5.4 million in assets that they are going to be leaving to their children or their heirs.
And Becky, I know you and Jim do a lot of planning on these things. I think for 2017, it's going up. That federal exemption is going up to what?
Yeah, so for 2017, it's going up to 5.49. So every year it's indexed for inflation.
About almost $5.5 million. So if we have husband and wife situation, what do you do? How do you maximize that?
Yeah, so the one thing that you need to do is there's something called spousal portability. And that is the idea where you can combine the unused exemption from the first spouse with the second spouse, and then upon the second spouse dying. So in essence, you can stack those exemptions on top of each other. But the important thing to know with that potential stacking of those two exemptions is that you actually have to file a federal estate tax return upon the first spouse's death to preserve that spousal portability. So that would be one reason that you would need to consult with an attorney at the death upon a spouse, because you would need to file that federal estate tax return.
So to maximize it, I mean, using again the figures for 2017, you're really saying basically a couple would have to have an estate of $11 million, all but
Right.
$11 million before, and with deductions and everything, it probably would be an estate of $11 million by the time they'd have to pay
Actually,
any federal tax.
Correct. Yep.
All right, that's a very small, as Jim said, very, very small percentage of our population.
Yes.
Okay. So, comment was made earlier about how you wind up in the state. Now, you've you marshaled the assets, you've paid the bills, you have taken care of all the taxes, tax returns are all paid, and now, how do you wind up in the state? What are the options here? I'll start with you, Becky. We'll jump back and forth with both of you.
Sure. So in Pennsylvania, you can settle an estate informally or formally. So I would say most of our estates, we do end up settling informally. And that process is more simple as far as once everything is paid, the taxes are paid, you have back all the notices that you need from the IRS, the Department of Revenue, all your tax returns are accepted. Then at that point, the executor would prepare an accounting which would outline all the assets that came into the estate and all the expenses that were paid. And then that, along with a release or a family settlement agreement, is sent to each of the beneficiaries. And they review that, sign off on that, and then the checks are issued for the distribution. And the purpose of that accounting and the release is, one, transparency, so that way all the beneficiaries know what was going on with the administration and what was paid and what came in. But then also that protection of liability for the executor, that each of the beneficiaries are agreeing to that accounting as if it had been filed formally with the court.
So Becky, you've just described the informal way, and
Right.
and yet there's you've mentioned, Jim, she's mentioned a more formal way. And what is that process, and when might we be doing that?
So it bears a lot of similarities to the informal process in the sense that you're still going to be preparing an account. You're still going to be showing proposed distributions out if there's assets left. But instead of circulating that among the beneficiaries and asking them to approve it, what you do is you actually file it with the court, with the orphans court for the county that you're in, that the estate is located. The court will schedule a time where that account will go before the court. People can object to it if they decide that there's something in there that they don't like. At that point, there might be subsequent hearings to figure out those objections, to resolve those objections if they can't be resolved otherwise. And at the end of the day, once all those objections have been resolved, one way or the other, the court will generally issue an order approving the account that was submitted as it may have been amended through that process, resulting in an order allowing you to distribute.
So this whole process from probate to concluding, how long does it take, Jim?
Again, I'll go back to the standard lawyer answer. It depends. I've had some estates that can be administered fairly quickly because there's liquid assets and it's just easier. But typically, you're looking at about a year to administer an estate from start to finish. Now, it can go longer than that depending on the assets. A couple years ago, particularly after the Great Recession, if an estate owned real estate, it may have taken 2, 3, 4 years to resolve it because that real estate needed to be sold.
You had to keep it open.
Yep.
Well, we're running out of time, and I just want to say thank you to Jim, Becky, and thank you to all of you for enjoying this program. I hope that you've at least have some insight into the issues facing us all when someone dies, and I look forward to seeing all of you, as do the other members of our firm, to consult with us on these issues, do proper planning. So join us at in our Pottstown office or Phoenixville office or online at owmlaw.com. Thank you.